4 possible types of business. Then you had the 5 decision makers. Capital, ease of creation, control, taxation, and liability. Liability, of course, kind of trumps the other ones. And you need to be able to tell me this is a form of business issue. These 3 people need to decide between the 4 business models and name what they are. They need to go through the 5 decision makers. 1, 2, 3, 4, 5. Don't make me read the whole paper to have to find the 5. Just list them. And then take each, if you chose LLC or if you chose limited partnership, apply it to each one of the decision makers. Now that's a B plus, A minus type answer. If you want to jump it up to an A plus, if you have time, and it takes a long time to take the test, if you have time, then tell me why they don't apply. If you chose partnership, tell me why they don't apply to corporation. Give me the opposite, so that I can see that you understand both. Chapter 15. Partnerships in specific. Express partnership is one that is written, usually on a general partnership agreement. They can be handshakes, it can be on a napkin, just a sticky note, but a good partnership, even if it's for a small business, we'll use a general partnership agreement to talk about what happens if somebody dies, what happens if somebody gets a divorce, what happens if the building burns down. I mean, how are we going to split the profits up? So a general partnership agreement is a good idea. We also discussed an implied partnership. An implied partnership is a partnership because of the acts of the partners. If you put 2 names on the side of a truck, you run the danger of the public saying you're a partnership because you got both names on the truck. You know, if you have a joint banking account, if you are running 2 businesses out of one building, if it's something that you're doing that the public can think that makes you a partner, that's called an implied partnership as opposed to an express partnership. Then did chapter 1. Which is source of law. As a part of chapter 1 is chapter 4, which is separation of powers. We have the legislative branch or Congress. We have the executive branch, or president or governor, and we have the judicial branch. Common law is judge-made. Judge-made. There is no statute. There is no written law. There is no piece of paper. But the judge says, based on these facts, I'm going to say that this is what happened. That the truck hit the car. I'm going to say that the cow belongs to the farm where it left, not the farm where it ended up. Judge-made. That's called common law. Common law is a big deal in America. Yes, sir.
The person says source of what?
Source of laws. Where they come from. We have regulatory, which are regulations. They come from the president. Regulations are the alphabet agencies, IRS, FBI, Environmental Protection Agency, Department of Health and Environmental Control, anything like that comes under the president or the governor. So they are regulations. And then finally, we have statutes. Statutes come from the legislature. Statutes are written laws. That's the best way to describe it. A written law is a statute. And you have books that are full of them. After chapter 1 and 4, we did chapter 2, which was the judicial. It expands on the judicial down here where it's a common law. On page 19 of your book, you will see that the Supreme Court of the United States is at the top, and under that is the Circuit Court of Appeals. Under that is the District Court. This is the federal branch. To get in the federal branch, you have to have $75,000 or more, or 2 or more states, or jurisdiction. Jurisdiction. State. State jurisdiction is everything else. And in South Carolina, you would have the Supreme Court, you would have the Court of Appeals, and you would have the Circuit Court. Circuit Court is the trial court in state. And federal, the district court is the trial court. And then you appeal it on the way up. We next did contracts. Contracts are a major part of this case, but they are very, very easy. Contracts, I will tell you, somebody promised them to pay $10 million and they didn't pay. If it's a promise and it wasn't followed through on, then it's a breach of contract. Or if I say there is a contract between Corporation A and Corporation B, you need to tell me what a contract is. You can do it in one sentence. A contract has an offer, an acceptance, and consideration, which is value. Contracts have to have all three. They have to have all three. After contracts, we did chapter 3, which was torts. Torts is an injury to a person or business not criminal, which is an injury to society. In order to have a tort, is an injury foreseeable if there's a toy in the aisle? Yes. All right, but is it reasonable for Walmart to pick up every toy that a child pulls off the aisle? Okay? You don't really know that. You're not in on the jury, so you need to tell me it may or may not be reasonable for Walmart to pick up every toy that a child drops in the aisle. I mean, that would require them to have an employee in every aisle. And that's just too expensive. If they slip on a banana, yes, that's a reasonable duty to have a clean floor. But if they trip over a toy, maybe it's not reasonable. Don't make a decision. Don't tell me it is or is not reasonable. Tell me that it has to be decided, that this is or is not reasonable. All right? And the injury, if the injury is a broken arm, that's foreseeable. If the injury is a broken arm and a broken leg and a broken pelvis and a broken head, then it's probably not foreseeable from tripping over a toy. So give me the options. After we did contracts and torts, we did chapter 11, which is litigation, which means lawsuits. In the exam, if I say anything about a lawsuit, if I say somebody wants to sue somebody, if I say somebody's hurt and they want to be rewarded, if I say they were in a wreck and they want to get their car fixed, anything like that, that's a hint that it's a lawsuit. All right? I'm not going to tell you Corporation A sues Corporation B, but I may tell you Corporation A bought something from Corporation B and they paid for it and they never got what they bought. That's a hint that it's litigation. All right? Civil litigation, just like torts, not criminal. Even though you still have the word defendant, even though there's a line of things that I put on the board, and even though it all ends up into a trial, criminal and civil are different. So don't get them mixed up. Civil litigation. Number one, cause of action. Why can you sue? I've been hurt, I haven't been paid. Cause of action for your exam is either going to be a tort or a breach of contract. On one of the practice tests, I had said it would be a tort or breach of contract, and some people covered both. All right, it's either one or the other. It's either a breach of contract or a tort. So after you get the cause of action, what do you do next? Jurisdiction. Where do you sue? Why do you sue? Where do you sue? Those are the first two decisions to make. Jurisdiction goes all the way back to the jurisdiction judicial, whether it's federal or whether it's state. So you will tell me that, you know, the damages that they have, the breach of contract is $100,000, so it's more than $75,000, or somebody's medical expenses are more than $75,000, or they fell in a store and hurt themselves, but the store is based in New York instead of in the South, so it'd be two or more states. If it's a South Carolina business and they're hurt in South Carolina, it would be a state. So cause of action, why are you suing, jurisdiction, where are you suing, and then 3, plaintiff. Plaintiff files a complaint. which is exactly what it is. It complains that I've been hurt, or I have not been paid. The defendant, not the criminal defendant, the civil defendant, files an answer that says, I don't owe you any money, or I didn't hurt you. The defendant can then file a counterclaim. Which says, not only do I not owe you any money, you owe me money. And the plaintiff has to file a reply saying, no, I don't. Now, important. Those are pleadings. You can have the best exam I've ever read, and if it doesn't have the word pleadings in it, you've left something out. Pleadings are important because after pleadings, and only after pleadings, can we get discovery. You can't discover anything until you know what they have complained. So discovery comes after pleadings, and discovery is important. Discovery is exchange of information. You do that by two ways. Deposition, which is in person, or interrogatories, which are written. In civil court, not in criminal court. In civil court, you know who all the witnesses are. You know what all the evidence is. If there's a wrecked car, you get to go look at it. If there's a driver that was drunk, you get to go talk to him. If he got drunk at Poor Richard's, you get to go to Poor Richard's and talk to him. Did you serve alcohol to this person? Okay, you learn everything that you can about the case. And the reason you do that is because the fifth step alternative dispute resolution. Alternative to the trial. Dispute for the tort of the contract. Resolution to solve the problem. Why do you need alternative dispute resolution?
Somebody wants to go to trial.
Okay, and the trial is over here by the door. I mean, we got another year before we get to trial. And so why do we not want to wait that year? Time equals money. People cannot afford to wait. So they do one negotiation. Negotiation, the two attorneys get on the telephone. I'll offer you $5 million. No, we want $7 million. And so they settle for $6 million. And they go to the client, and one of the clients says, that's not enough, or I don't want to pay it. So negotiation is not final. So then you have a little mini trial called mediation. And mediation, you have a mediator, maybe a retired judge, a retired lawyer, maybe a professor, and he goes to a conference room, no jury, but they look at all of the discovery, they look at all the witnesses, they read the interrogatories, they talk to the witnesses, and after a couple of days, they say, we think Corporation B owes Corporation A $5 million. And one of the two, either Corporation B says, I don't want to pay it, or Corporation A says, that's not enough. Because at the end of the mediation, it's not final. They can't agree. So the mediation is not final. That leads us to arbitration. arbitration is just like mediation. You have a pretend judge who talks to all the witnesses and looks at all the discovery and looks at all the evidence, and the arbitration says what Corporation B owes Corporation A, and it is final because each party, the plaintiff and the defendant, sign a contract that says whatever happens in arbitration, we'll stick by it. We'll take whatever happens in arbitration, even if it costs us money or even if we lose. We'll take our chances with arbitration. And this contract, basically they are contracting away their right to trial. They're contracting away their right to trial. And because trial's down the road. Now, good news for y'all. If I do a litigation question, when you get to arbitration, you just simply need to tell me that the issue would be over. If they don't agree to go to arbitration, then you would tell me that they then go to trial. I am not making you go through the trial. Go through the jury and the jury venire and the judge's motions and the clerk of court calling people's names and the jury coming back, with a verdict. So litigation is going to stop with the alternative dispute. All right, any questions so far? After litigation, we did criminal. Criminals do it on purpose, intentionally, or they do it through their actions. Mens rea and actus rea. Police need a search and seizure warrant. Get that, they go to show probable cause to a judge. They then go seize whatever they're looking for. They look for everything in the closets. They take computers, look for guns, whatever they're looking for. Right? And then they find something. So the police then go to a grand jury. And the grand jury, they have to show 18 people that there's probable cause that a crime has been committed, in which case they get an arrest warrant. A plus answer. Fourth Amendment. Fifth Amendment. All right. Once the defendant is arrested, he goes to trial. The only thing you need to know, I'm not going to make you go through picking the jury and all of that. All the things you need to know is that the state or the feds Prove beyond a reasonable doubt. Now, in civil litigation, it's the preponderance of the evidence. You know, who owes the money, whose fault was it, who didn't sweep the floor, who caused the wreck. In a criminal trial, the state has to prove it beyond a reasonable doubt. I'm going to give you one more thing, and I don't care if you put it on the exam or not. If you do, it's extra credit. But just for your education, I don't think I talked enough about something called Brady material. You know how we have discovery in civil cases? In criminal cases, you don't get to know everything that the police has against you. The police can have surprise witnesses and surprise evidence, but you do get to know some stuff. And that's called Brady material over a case in Maryland called Maryland versus Brady. And the state has to give to the defendant anything that helps him. All right. So let's say the state has, let's say that Maggie has committed a crime. All right. And I'm the prosecutor, and I know that Francisco saw her do it. All right. I don't have to tell her that. He can be my surprise witness because he saw her do it. But let's say that they say that Noelia was with her and they were playing golf and she couldn't have done it. Well, if they interview Noelia, they have to tell me that. If they have something that helps me, they have to tell me. If they have something that hurts me, they get to surprise me with it. And that's called Brady material. Throw that in the exam, that's an A++++. I just thought you ought to know it. Property. Chapter 9 and 10, personal property, you have to have ownership, title, and possession. You have to have all three, kind of like contracts. And the best example of that is the used car dealer that goes to buy cars at an auction and he doesn't get the titles. And so he comes back and he sells the car and says, well, the auction told me they would mail me the title, but the auction doesn't have the title. The cars may very well be stolen or sold 3, 4, 5, 6, 7 times. So you don't have possession, you don't have ownership of it until you have the title. So you have to go to the Department of Motor Vehicle and get a lost title. Right? Real property is land plus fixtures. Fixtures are easy. Fixtures are things that can't be moved. Think of it as you buy a farm and it has a barn on it. The barn is called a fixture. They got a couple of tractors on it. Those are not fixtures. Those are personal property. And the seller can drive the tractors away, or he can sell you the tractors, but they don't come with the land. The fixture comes with the land. In order to buy property, a grantor sells to a grantee by way of a deed, and the deed has a property description. And that property description must be the same describing that property for 70 years. If you go back 70 years and you find a deed that says it's 99 acres instead of 100 acres, you got a problem. You got to go find that other acre. So the grantor sells to the grantee by deed, and the important part of the deed is the property description. Buy a piece of property, 100 acres, you put a warehouse on it, that's now a fixture, and you put a fence around the property, and somebody comes along and says, wait a minute, I can't get to my house, I've got a driveway down the side of that property, and it's in the property description, and you just ignored it, and that is called an easement. If it's a neighborhood, people just say, okay, fine, use the dirt road. If it's a corporation that's bought 100 acres, they're probably going to buy out the easement. What can we pay you for your house and your dirt road? And get rid of it. There's also a little piece of land in the back that somebody's lived there for 25 or more years. That's called adverse possession. And adverse possession is a lawsuit. If you got adverse possession on your property, you sue them because it's almost impossible to prove adverse possession. I mean, if they went on vacation, they didn't live there for 25 years. It's got to be 25 continuous years, which is very hard to do. Then you have the road that the state comes in and takes the front part of your property. They can absolutely do that. Eminent domain. And they make you an offer for that piece. You don't want it. And they say, well, we paid $50K for this piece over here. We'll offer you $50K. And you want $100K. And so you go to trial, and the jury decides who gets what for the land. All right? A+++. The money that you get is called just compensation. And that is the 14th Amendment. And it's not like just money. It's like justice compensation. It's fair compensation. If I haven't missed any, we've got two more. Just bear with me. Damages. Compensatory. That compensates for what you've lost, also called actual damages, consequential damages. That's like attorney's fees, lost wages. Nominal. The jury says you win, but it was also your fault, so we're only going to give you $1. And then punitive, which is to punish, where you get in a wreck and your medical bills and to fix your car is $5,000, but the guy was drunk driving 100 miles an hour, so you get $1 million for punitive. Bankruptcy. Bankruptcy is in chapters. It is federal only. Chapter 7, liquidation. You'll close the shop. Chapter 11, reorganization. Bankruptcy judge appoints a trustee who collects assets and pays percentage of the debt. All right.